Searle.
Mr President, I lead for the opposition on the Privacy and Personal Information Protection Amendment Exemptions Consolidation Bill 2015. I state at the outset the opposition does not oppose the bill, and we will be supporting the government's amendments to its own bill for the reasons outlined by the Honourable Parliamentary Secretary. That is, that the Privacy Commissioner has requested those changes to the legislation now before the House. There are two broad objectives of the bill. One is to consolidate and rationalise exemptions to the information protection principles under the primary Act, the Privacy and Personal Information Protection Act, known as PIPA, that have been previously long-term exemptions under public interest directions, or PIDs, by the Privacy Commissioner. This is achieved by amendments to legislation in this bill and amendments to the Privacy Code of Practice. The second object is to provide amendments to the Principal Act that allow disclosure of personal information for research purposes, that make it clear current exemptions concerning law enforcement include for the purposes of another state, territory or the Commonwealth, and to extend the meaning of investigative agency to include additional public sector agencies with an investigative role. In relation to the first of these objects, the Attorney in the other places provided an assurance that no change in policy or practice is intended, and I will assume, Mr Assistant President, the same assurance is given by the Honourable Parliamentary Secretary in this place. The first of these objectives relate to public interest disclosures issued under Section 41. These are directions made in writing by the Privacy Commissioner with the approval of the Minister, in this case the Attorney General, indicating that an agency is not required to comply with an information protection principle or a privacy code of conduct. Section 41(3) requires that the Privacy Commissioner be satisfied that the public interest in requiring the agency to comply with the principle or code is outweighed by the public interest in the Commissioner making that direction. The issue, of course, is that such directions were really intended to only apply temporarily until a more permanent and formal solution was determined. That is not quite what has happened with PIDs, as public interest directions are sometimes called in practice. To quote from the New South Wales Law Reform Commission report, Protecting Privacy in New South Wales, from May 2010, at paragraph 7.68, it said, and I quote, "However, out of the 11 PIDs currently in place, 8 have been in place for over 6 years, and the remaining 3 have unspecified end dates," unquote. And at paragraph 7.69, it says, and I quote, "This confirms the observations made above with respect to privacy codes, namely that there exist significant practical shortcomings with the current system, and that similarly to privacy codes, the use of PIDs has been stretched, inverted commas, to allow agencies to function properly." The report then proceeds to quote from a statutory review of the Privacy and Personal Information Protection Act 1998, which said, and I quote, "The main problem with the use of Section 41 directions is that what should be a short-term solution to an information management problem becomes the effective long-term solution. The directions are simply remade continuously as they expire because of lack of satisfactory progress on negotiating a more long-term solution," unquote. At paragraph 7.70 of its report, the Commission concludes, and I quote, "We are of the view that a statutory basis for long-term exemptions is vastly preferable to the use of PIDs, and that the use of PIDs should be limited to the original intent behind the provisions as temporary measures," unquote. I understand that at least one of the PIDs has been in existence for up to 12 years. The PIDs that are dealt with by the bill include the following: direction on information transfers between public agencies, direction for the Department of Family and Community Services and associated agencies, direction on the processing of personal information by public sector agencies in relation to their investigative functions, direction on the disclosure of information to credit reporting agencies, directing on disclosures on information by the New South Wales public sector to the National Coronial Information System, direction on the collections of personal information about third parties by New South Wales public sector human services agencies from their clients, and direction on the disclosure of information to victims of crime. This is undoubtedly a positive development, but some practical issues arise. The use of PIDs and the reissuing of them could provide a review mechanism of their terms and whether they need to remain in the same terms. That level of flexibility is lost in pursuing a statutory version. There also remain weaknesses in the regime. There is no mandatory reporting to the Privacy Commissioner of serious breaches of the principles. In that context, I note recommendation 9.2 of the New South Wales Law Reform Commission report number 127. This bill conveys the sense of cherry-picking from the recommendations of the Commission's report. I also note that this recommendation was contained in the report of the Privacy Commissioner dated May 2015 and tabled in the Parliament. The lack of resources for the Privacy Commissioner exacerbates this weakness. Resourcing issues were also raised in the Privacy Commissioner's report and have attracted the attention of the Parliamentary Oversight Committee, of which both I and the Shadow Attorney in the other place are members. I think given the rapid development we are seeing in the privacy space, driven by the technological revolution of the internet and social media, there is a compelling case for a much better resourced and full-time Privacy Commission for this state, one with more teeth and equipment in her toolbox. There are provisions in this bill outside the scope of the PID issue. The definition of investigative agency, quote unquote, is expanded to become more general, as well as specifying particular agencies. This seems reminiscent of some of the recommendations in the New South Wales Law Reform Commission report to which I have referred, Mr Assistant President. Section 19 is amended by this bill as it imposes restrictions on disclosure to a person or body in a jurisdiction outside New South Wales or to a Commonwealth agency. This follows a 2008 decision by the Administrative Decisions Tribunal made, full stop. Trans-border disclosure will be regulated by this new provision, which is said to be based on the Health Records and Information Privacy Act 2002. Similarly, the extraterritorial transfer of personal information concerning law enforcement is amended to take account of the 2008 decision by the Administrative Decisions Tribunal. Section 27B provides a new exemption relating to research. This replaced another PID, but in different and hopefully clearer terms. As I indicated at the outset, Mr Assistant President, the opposition does not oppose the bill, and we will be supporting the government amendment.